killed. The investigation under the police of criminal case under the Army Act, Navy Act, Air Force Act is done by a cumbersome procedure which is known as court of inquiry. Then there is a summary of evidence, and then the charges are framed, then it goes to the tribunal. So that procedure is cumbersome, and therefore there have been recommendations for curtailing this procedure. But another aspect of court-martial system which is subject to criticism is that there is no permanent system of court-martial. There is no permanent body or tribunal which does the court-martial. As and when a case comes, the commander constitutes a court and gives it to the court for court-martial. And the court which is created is a temporary one. Today, depending upon the rank of the officer, a major general may head the court-martial as a presiding officer. He will have two officers. Tomorrow, if another court-martial comes, it may go. So therefore, the persons manning the court-martial are different. It's not a thing where the same person does everything and they are guided by the advice of the judge advocate. They do it. So therefore, there has been an allegation that what we call in military terms that the court-martial is done under the command influence. Command influence means the commander, even though he creates the court-martial, he takes a decision as to what should be done, and that command influence makes the court-martial, loses the significance of independence of the court-martial. And even though in the we do try to remove that, but then the demand is that a permanent tribunal should be created for the purpose of trying the court-martial. There are various opinions where it says that at unit level or at command level, you should have a permanent body of persons who will be known as the court-martial tribunals, and they will do the court-martial, and they will be doing only court-martial. I can share with you an experience which I had about 2 months back. The Judge Advocate General of England came, and he was saying, you have taken the Army Act from where we left, and you are going on with that with some amendment. But we in the European countries and England have an act made in 2006, which is different from that, and we have created independent tribunals to deal with court-martial, and a judicial officer who can be appointed as a judge of the High Court heads the court-martial tribunal, and he conducts trial for all Army, Navy and Air Force, and from his order, the appeal goes to the High Court. So in India also, there is a demand for a